Hey everybody. Wow, it's one of those history videos that I do every 6 months. Anyway, court cases. I don't think anybody really likes them. Granted, they're not a topic that comes up in daily conversation, but on the whole, they're something people generally try to avoid, whenever possible. I myself am not particularly hot on them, seeing as how every decent sci-fi show seems to have an episode about them, and they generally suck. But I digress. Court cases, in general, are pretty boring. But that doesn't mean there aren't a few interesting ones. Every so often, someone gets in their head to go to court with something truly remarkable in mind, or in some cases, something truly insane. Today, I'm going to be taking a look into some of the strangest lawsuits in recent history. We'll start off with one that some among you might actually have heard of. On March 22, 2005, California resident Ann Ayala claimed that she had found none other than a full-on human finger adorning her bowl of Wendy's chili. Ayala was understandably quite distressed by this discovery, and she promptly sued the Wendy's restaurant in question for the potential harm said finger could have caused. The resulting chaos was a definite loss for Wendy's, as the company reportedly dropped over $20 million in lost revenue, as people avoided dining out for fear of getting fingered themselves. However, the case was not as cut and dry as it had initially seemed. The Santa Clara Medical Examiner's Office, after a thorough investigation, determined that the finger did not, in fact, come from any of the Wendy's staff or from any individuals who might have been involved in the chili's production. On top of this, the Santa Clara Coroner's Office proceeded to do their own finger investigation and determined that, shockingly, the finger itself had not been cooked, leading the investigators to deduce that it had instead been planted in the chili after the fact. In the face of overwhelming evidence, Ayala pled guilty to the charge of grand larceny and was sentenced to 9 years behind bars in 2006 for her crimes against fast food. Her sentence was appealed at a later date, after which she promptly landed herself back in jail again for being an accessory to a felony in 2013. Around the time of Ayala's first incarceration, an Oregon man had a brilliant plan to file a suit of a very different nature. Alan Heckard, age 51, was fed up. What was he fed up with, by chance? A simple, everyday occurrence. Heckard was tired of being mistaken for Michael Jordan. I'll show an actual side-by-side here for reference, but essentially, Heckard believed he had been dealt permanent mental and emotional damage due to people mistaking him for MJ. As a result, he did the logical thing and sued both Jordan himself and Nike founder Phil Knight for two equal sums of $416 million. Unfortunately for Heckard, the case was dismissed, and Allen was forced to live out the rest of his life knowing his identity had been stolen. Now, Michael Jordan is a lofty target for certain, but this time let's aim a little higher, or in this specific instance, all the way up. Nebraska Senator Ernie Chambers was renowned for the remarkable leaps he made during his multiple decades as part of the state legislature, but in 2007, Chambers was on a mission that would baffle many across the country. A movement in the Nebraska legislature during that year had begun with the intent to ban the often dismissed but infinitely entertaining frivolous lawsuits from Nebraska courts. Chambers, firmly believing that this action would infringe on the state's promise that its courthouses would always be open to any who needed them, crafted a plan to demonstrate the freedom all citizens should be afforded in regards to court action. Simply put, Chambers was going to sue God. Chambers referenced God's role in numerous natural disasters, destruction, and, of course, acts of God, all of which he stated had brought damage to Earth's inhabitants. The suit was ultimately unsuccessful, the judge citing an unlisted home address as the reasoning for which God could not be sued, but Chambers certainly made his point, and his ultimate display of punching up has continued to make headlines across the nation. So now you know God can be sued, but what if we go in the opposite direction? In December of 1971, a Pennsylvania convict named Gerald Mayo was feeling maligned by someone or something. He felt that some outside force had been responsible for his unfortunate status. So, Mayo decided to take action. He was going to sue the devil. In the incredibly named United States ex rel Gerald Mayo v. Satan and his staff case, Mayo claimed that Lucifer himself had, quote, on numerous occasions caused plaintiff misery and placed deliberate obstacles in his path that caused the plaintiff's downfall. Mayo was making the suit in forma pauperis, meaning essentially that he was flat broke and wanted the state to pay the court fees. The court mediated over the case for a while, and although they were able to determine that Satan would officially be classified as a foreign prince, they were not able to carry out the suit due to a number of shortcomings. Sadly, Mayo's case was dismissed, and Satan was able to get off scot-free. Truly an unfair world we live in. Now, so far we've established that God, Satan, Wendy's, and even Michael Jordan are all potential victims of a vengeful lawsuit. But as is often said, a man's greatest enemy is often himself. This is a theory that one Chesapeake Penitentiary inmate set out to prove by power of law in 1995. In March of that year, Virginia convict Robert Lee Brock filed a 7-page lawsuit of his own creation in federal court. The defendant? Robert Lee Brock. Serving 23 years for larceny and breaking and entering, Brock had decided that the person at fault for his imprisonment was none other than himself, but not exactly in the way you'd expect. More specifically, Brock essentially claimed that by drinking alcohol and getting arrested in '93, he had caused himself to violate his religious beliefs, an offense he believed was worth a solid $5 million in damages. $5 million that, as a ward of the state, Brock couldn't exactly pay, meaning that if he had won the case, the state would have supplied the required funds. The court was impressed by his ingenuity, which they congratulated him on, before booting him out of the court and sending him right back to prison. Let's go back in time a bit, to the 1890s, a wonderful time in which cocaine could cure malaria and rat poison was being used for steroids. Influenza was starting to make its rounds, and entrepreneurial snake oil salesmen were jumping on the opportunity to make a quick buck, or rather a quick cent, since this was the 1890s. In particular, a company called the Carbolic Smokeball Co. emerged and began selling its flagship product, the creatively named Carbolic Smokeball. The device itself was a rubber ball with a hose attached that was filled with phenol, a compound extracted from coal tar that would in later years be used to create plastics. Clearly, this was the medicine of the future, and the company was so confident in their ball that they claimed they would compensate any smokeball user who did not have their influenza cured for a total of £100. Now, this doesn't sound like that big of a deal until you realize that, calculated for inflation, that's a little over £10,000 in today's money. As a result, when London resident Louisa Carlyle found that, even after excessive use of the ball, she still contracted influenza, she was ready to pursue the cash. Unfortunately, the company repeatedly rejected Carlyle's request for a reimbursement, and after a cryptic response sent by mail, Carlyle took the company to court. In a shocking twist of fate, the court actually sided with Carlyle, ordering the smokeballers to reimburse her for the promised amount. Amidst the ranks of weird, failed court cases, this stunning victory certainly stands out. Well, we're already in the 19th century, so let's stay here a little longer while we discuss a case that you probably have never heard of, but whose effects you've almost certainly seen today. Let me explain. A man named John Nix founded the John Nix & Co. Fruit Company in New York in 1839, shipping fruits from fruit areas to non-fruit areas. In 1883, President Arthur, who I'm certain you've probably never heard of before, signed the Tariff Act of 1883 into effect. The act required, among other things, that imported vegetables would be subject to taxation, while fruits would not be. Normally, this wouldn't be a problem for my man Nix, but unfortunately for him, his shipments of tomatoes happened to fall under the qualifications for taxation. So, exercising his rights to go to court for anything and everything, Nix headed off to the courthouse to declare once and for all that his tomatoes were in fact fruits, and as such, were not to be victims of taxation. The case went on a lot longer than you might initially think, and at points they ended up bringing in witnesses, consulting several dictionaries, and speaking to experts in the field of tomato. Finally, after much deliberation, the court made a declaration that would echo throughout history. In the eyes of the law and the tariff department, a tomato was indeed a vegetable, meaning Nix would have no choice but to fork over the cash. And thus ended the saga of John Nix and his tomatoes. So, what's the big lesson to be learned here? Is it not to go to court with a case you can win? To avoid trying to make a quick buck with a fraudulent claim? Or is it just that we should always be on the lookout for idiots with a lawsuit? Hell if I know. Oh, by the way, if you haven't liked this video by now, I'll be seeing you in court, bud. Thanks for watching.